Welcome, everybody, to a very important episode of the Gold Silver Bitcoin Show. We are more than honored to be sitting down today with Norm Pattis, an American leading lawyer, most recently the lawyer for Alex Jones in the Alex Jones trial in Connecticut. Norm has been on our show before, and so much has changed since then in the world, I think underscored by Tulsi Gabbard's reasoning for leaving the Democrat Party, this um, notion of there being a global elite, a cabal, if you will. And so we're really happy to catch up again with Norm Pattis. Thank you so much for joining us today.
Thanks for having me back. It's been a while. Been what, about 8, 9 months?
If not a year already.
Oh my, wow.
Really
Wow.
excited to have you on. You're one of my favorite guests. So how's everything with you? What are you keeping an eye on?
Well, my border collie, I'm up in northern Vermont right now, taking a little bit of time off, but I'm busily writing post-trial briefs after the Alex Jones case. My friends, some of my good friends are personal injury lawyers. And, if you saw the news, you saw Jones got hit with $1 billion in compensatory damages, and I was his lawyer. So it's not exactly the kind of history I wanted to make. So a good friend of mine who's a big-time PI lawyer out your way called, and he said, you should do an ad. And I said, I should? He said, yeah, you could tell people you're $1 billion lawyer. I said, I lost that case. He said, well, you don't have to say that. But I mean, that case is keeping me busy. And it bears talking about, because a lot of people are trying to say that it sets a precedent for lawfare. And what can happen to other controversial speakers such as Ye, and who knows who's next. Alex and Ye are low-hanging fruit. They're easy right now. But one of the things, and we'll talk about this in a bit, that they have in common is a preoccupation with George Soros and the World Economic Forum, the very thing that you mentioned. And I think people are starting to wake up to the fact that there is something funky going on in the world. But with Jones, here's what happened. Jones obviously is a conspiracy theorist. He doesn't trust the government. He doesn't trust mainstream media. And when things happen, I think he believes that Rahm Emanuel meant what he said, which is never let a good crisis go to waste. His default reaction whenever there was a mass shooting was to think, now what did the government set up? Now what are they going to do to take our guns? And in the Sandy Hook case, he raised doubts about the reality of what those parents endured and about the suffering that their community endured. I don't live far from Sandy Hook. I had a friend who lost a stepdaughter there. There was never any question in my mind that it was real. But to Jones, sitting 1,000 miles away, how was he to determine that this was any more real than the Tuskegee experiments, or the Kennedy being shot by one person, or those 9/11 truthers who doubt the reality that it was a terrorist attack? I've never doubted these things in any serious way. And I began to wonder about just why some doubt and why I don't. But Jones said these things. He said it in 2012 when the shooting occurred in December, in 13 and 14. And along the way, he had guests on who talked about this, truthers, not, Sandy Hook truthers. Nothing happened. 2013 passed, 2014 passed, 2015 passed, 2016 passed, 2017 passed. Then all of a sudden in 2018, he got sued by 16 of the parents and surviving family members. What changed? Well, one of the things that changed is that in 2016, Hillary Clinton went after Alex in her presidential campaign, in particular his treatment of the folks at Sandy Hook. Donald Trump appeared on Alex's show. And when he won, he promised Alex that he'd never disappoint him. I don't think the left ever forgave Alex for that. And I think the maelstrom that led to this litigation 6 years after the fact was part of the attempt to silence him, because he was raising questions that are inconvenient and in some cases crazy, like the Sandy Hook stuff, I think is crazy. But as to Davos, as to big data, as to social utility scores, as to big techs taking over our government, our lives, and as to the influence of China, the World Economic Forum, and others on global affairs, I think Alex was right. And so he gets filed in 2018. He asks that Mark Randazza, a very prominent First Amendment lawyer, excuse me while I adjust something so the dog doesn't drive us nuts. He asks for the court for permission to have Mark Randazza, one of the nation's leading First Amendment lawyers, somebody who I would think you'd love to have on your show, maybe you have. He asked to have Mark Randazza admit him by way of a process called pro hoc vice, not admitted in Connecticut, but permitted to appear. Denied. It almost never happens. So he was denied the counsel of choice. The plaintiff's lawyers then loaded him up with enormous discovery requests in preliminary proceedings that were designed to give him permission to try to throw the suit out on First Amendment grounds. And he never recovered from those discovery requests. The plaintiff's lawyers tried to treat his company as though it were IBM. And when he couldn't respond with a standard of perfection, they began moving for a series of defaults ultimately, they got a default on liability, and the trial was only a hearing in damages. Jones never had a chance to defend on the merits. The way the trial unfolded, the judge made extraordinary rulings on causation. She ruled that any harm, emotional distress, or harassment or intimidation that these folks suffered after 2012 was Alex's fault from anyone in the world under any circumstances. So, for the first time in my legal career, I had witnesses testify that Jane Doe told me that Mr. X urinated on my child's grave. That was devastating, as that news would be. But from a lawyer's perspective, is that hearsay? Is somebody's out-of-court statement being used to prove the truth of the matter asserted? Objection, hearsay, denied. What about a foundation? What about an attempt to link this to Alex Jones? Oh no, the law of the case is that it's all his fault. And so I sat through a trial where Jones was made responsible for the reaction of anyone who looked funny at those parents over the years. And so we heard stories about death threats over the phone without hearing the phone calls or identifying the declarant. We heard stories about notes left on doors without seeing the notes, knowing who put them there, or even necessarily what they meant. We heard stories about things plastered on windshield. We heard about confrontations with anonymous people on the street. And the jury was lied to. The jury was told that it had been established that Jones was responsible for that. And the jury never knew what that meant. The jury never knew that as a result of Jones's failure to comply with the plaintiff's extraordinary discovery requests, he was liable for things he may not have done. And so when it came time to assess damages, the plaintiffs, none of them offered bills of any sort. There was no medical testimony. They testified about how upsetting all this was, and none of them asked for a particular dollar amount. But their lawyer got up and asked for the world, and he got a bunch. And so now you ask what I'm busy with. Last week, I filed a couple briefs, one for a new trial. It's a trial level motion. It's short of an appeal. I asked for the damages to be reduced or remitted. Friday of this week, we have additional briefs due on such punitive damages as the court may have discretion to award. So I'm plenty busy in the Alex Jones case. And, hopefully we'll get the case to judgment sometime in November, and then we'll go on to appeal.
And if the appeal was granted, would it be seen in a higher court as a new trial?
Yes, perhaps. So, obviously I haven't thought through the issues to raise on an appeal. There's so many, I feel like a kid in a candy shop. And you get only so many pages. I think it'll be 40 pages in this case, given the types of issues we want to raise, which may sound like a lot, but it's not. I remember once in a death penalty case, we had unlimited briefing. I wrote 256 pages of briefs, in that appeal, and we only won one issue, but it was enough to save the man's life. But the relief I'm seeking for, I want a new trial, and I want the default set aside. For example, consider the following. Suppose I sue you and I ask you, and I think, wait, this is a prominent podcast. He must have a staff of thousands and he must be making $1 gazillion. Give me all your financial records. Give me your organizational flowchart. Tell me where all the places you spoke at around the world in the last 2 years. Suppose I'm not satisfied with the response you give me and I go to the judge and I say, he's holding out on me. There's more. And the judge agrees with you. Now you get a default. Now you go to trial and you get to use what I have given you, what little I have given you. You get to use it against me and ask the jury to draw an inference. There's more that I must have hidden. That's not a fair trial. That it's just not. Now, Alex, to his credit, and he's got bigger cojones than just about anybody I know. On his show, he called it a kangaroo court. He showed a picture of the judge with the banner beneath it, contempt and lasers coming out of his eyes. When he got on the witness stand, the lawyer for the plaintiff showed him that. And they said, did you do that? He says, yeah. And you called the judge a tyrant, didn't you? Well, I did. I think she is. And, it was bold testimony. I don't know what, I guess we know what the jury made of it because they heard him bad. It was $965,000, $1 million. The punitive damages component of this case could easily add another billion or more to the case. There could be an attorney's fee award in the range of $300 to $400 million. So this case could top out at $2.5 billion.
And a lot of businesses are so busy that they don't have time to keep everything so neat and orderly as, say, a regulated company, a public company, for instance.
No, and I think in Alex's case, he started out in community access television, I think in the late 90s, at about the time of the Waco bomb, firebombing of the Koresh complex. And his show took off immediately. And within a matter of months, he was one of the top rated shows in the Austin area. And within years, he was one of the top radio television acts, as it were. And a decade or so later, he was huge. And, his family and his friends and his colleagues tried to keep pace with that growth. They made a lot of money. Not as much as everybody thinks. That $1 billion verdict is going to go uncollected, but they never organized well enough to keep track of what was going on, and it caught him. And I was struck because right after the verdict in his case was returned, I came up to northern Vermont where I hang out whenever I get a chance to relax, and I was ignoring the news, and then I got a call. Did you see what happened to Ye? Kanye West. And the anti-Semitism remark, and suddenly he's being canceled everywhere. And now there's a threat that George Floyd's family is going to sue him, and they're going to use the Alex Jones case as a precedent. And this person who called me is pretty well connected. I said, get back to Ye and tell him whatever he does, get your shit together, get organized, and don't let yourself get defaulted. Because in the Floyd case in particular, there are valid defenses on the merits, and I hope that he raises them. So.
In your closing argument, you told the jury that there's no place you'd rather be than right there defending Alex Jones. Can you elaborate on that?
Yeah, I'm wired to, I'm a contrarian. And I believe that there is no mob more dangerous than a self-righteous mob. Look at what's happened to Kanye West in the last few days. Due process, fair proceedings. Has anybody asked him, what he did, what he said, why he said it, what he meant by what he said? Lex Friedman, who does the Lex Friedman podcast, does a lot of AI work. He had Kanye on for a 2-hour and 26-minute interview the other day, and I watched it. And I watched Kanye try to give an account of what he said. I'm not sure he persuaded me, but he gave me something to think about. And in those 2 hours, I bet you those 2 hours and 26 minutes that he spent with Lex Friedman is longer than it took the boards of many of these woke corporations to cut their ties with him, because they're a self-righteous mob feeding off the fumes of one another's rage. And so with respect to Jones, defending him in Connecticut was not easy. The Sandy Hook trial took place about 20 miles from Sandy Hook. The 10th anniversary of the event is occurring in December, and people are still raw by it. He's very much hated in Connecticut. But I said to the jury, and I believed it at the time, that there was no place in the world I would rather be at that moment than right there with them, right now, right here with you, defending Alex Jones, because this is where the rule of law gets put to the test, where the person who is despised, where a person who's done things allegedly beyond the pale, is judged according to legal standards by a jury of his peers. And so I was proud to represent Jones. And I'm still proud to represent Jones, although I'm ready to strangle my dog if she won't stop yipping.
No, it's good. It makes for good internet. The internet likes dogs and cats. I'm curious, when it comes to Mr. Jones's appeal, how do you expect that process to play out for him?
So generally, I've argued hundreds of appeals at various appellate courts across the country. Our firm has appeared in the U.S. Supreme Court twice. I didn't argue either of those cases. I should have one of them, but I gave it to a senior partner figuring I'll get back. And, I didn't get back as quickly as I thought. But you try to pick your best issues. A lot can go wrong at trial. You don't want to pick on every error that you think a judge made, because if it's an error that doesn't matter, you're not going to get a new trial. So the first question you ask yourself on an appeal is, what do I want to see happen here? So what I want to see happen is I want to see Alex have a trial and have the ability to defend his case on the merits. So issue number one will be that the trial court erred in defaulting him for substantial noncompliance with discovery. That even if he hadn't complied to the extent the court wanted, the penalty was disproportionate to what he had done. A default is typically entered when a person refuses to participate, when they don't show up, when they ignore the proceedings. Alex and his people gave tens of thousands of documents to the Sandy Hook family's lawyers. They appeared for dozens of depositions, sitting for hundreds of hours in from 50 or 60 recorded sessions. They answered questions under oath. They provided documents and attested that they were true under oath. Some of them signed requests for admissions, admitting or denying certain facts under oath. They did all of this. We attended any number of status conferences. We argued, we briefed. thousands of hours of time were spent on this case chasing a phantom. And the phantom was the image of perfection that the plaintiff's lawyers persuaded the court should apply in this case. The sanction that she ordered, default, gave the plaintiffs the benefit of partial compliance, even if she's right. It gave them the benefit of partial compliance and a full default, depriving Jones of defending himself. So it was disproportionate. They got a benefit they shouldn't have, they weren't entitled to. So that's issue number one. Issue number two is the evisceration of the concept of causation in a hearing and damages. A trial is a two-act play. First act in a civil case, liability. Did a person do something wrong? Second, what's the consequence? What harm was shown? In this case, we skipped the first act and moved right to harm. And the judge said, as I said earlier, everything was Alex's fault. The law is that even in a hearing in damages, the plaintiff have to prove the extent of damages they seek. In this case, the judge gave them so much more than they were entitled to that the trial became a farce. And people watching it without understanding the context are entitled to think, what the hell's going on in our court? Even in the context I've given you, I still think it's a fair question. What the hell was going on in this case? So issue number two, it will be that we need a new trial because of the elimination of the concept of causation. Issue number three will pertain to is a fallback issue, as it were. You know, if we lose on issues 1 and 2, we still think the damages should be reduced because they don't bear any rational relationship to the evidence presented at trial. The plaintiffs had the burden of proving the extent of the damages they wanted in this case. They asked for nothing and talked about the terror and anxiety they expressed. What is that worth? And is it fair to say, we're just going to let a jury decide that and do whatever they want? We don't think it is. And so that would be issue number three. Beyond that, I mean, there are other things. And I'm like a kid in a candy shop. I'm picking and choosing, you know.
Could you elaborate upon causation?
In law school, in your first year, you take a class called torts. And torts is tort is a Latin word. Gotta throw the ball for the dog again. I am not behaving in a tortious manner as to my dog. I'm attending to your needs. Go. So a tort is twisted behavior. So, you know, it's behavior that violates the settled expectations of the community and is contrary to law. If a person violates a tort, do they then cause damage to another person? Now, causation is a bizarre concept. You just took a sip of coffee and you put the cup down. Now, you've heard of the butterfly effect. It's possible that 7 minutes from now, somebody will flick a switch in Siberia and send a nuclear weapon our way. Did your putting that cup down cause that? That would be the butterfly effect. You know, and the argument would be, well, somebody's listening to me in the car and they're trying to follow what I say. I watch you put the cup down. I hear it click. I comment on it. The guy scratches his head saying, wait a minute, what the heck was that? What was he talking about? And the moment he takes his eyes off the wheel, he rear ends somebody else and causes a massive collision somewhere up near Seattle. That results in somebody arriving late who is monitoring intelligence signals at their job. They're 2 minutes late, and in their rush to interpret the data, they miss an obvious signal, and they flick a switch alerting to a high-risk alert. That's our side of causation. On the other side, a series of other butterfly events occur, and the result is, with imperfect information, somebody starts World War III. Your reaction to that? That's ridiculous. It's bullshit. And it is, but it might be true bullshit. But the court says, look, we're not going to put every butterfly on trial. There's a concept called proximate cause. Proximate cause is cause that a person is responsible for. So if I'm driving through an intersection, not watching, and I run you down, I was a substantial factor in the event that caused your harm. If you were not paying attention, because you were wearing blindfolds on and reciting Latin verses about, you know, the Three Little Pigs, well, then you've contributed to that cause. You know, you are contributorily negligent. If somebody pushed you into the road, that might be a superseding, intervening cause, something that I wouldn't have hit you but for that event. And so the law talks about causation, and it tries to limit, proximate cause tries to limit causation to the harm that occurred. What I think happened in the Jones case is that when the court said anything that the plaintiffs did suffered is Jones's fault, she embraced the butterfly effect. She basically said that because Alex spoke about Sandy Hook and others listened, those others must have acted on what he said. And when they acted, they caused harm to the Sandy Hook parents, and therefore Jones caused it. It's a complete elimination of the limitations on legal causation that the courts routinely apply. And the court justified it by saying that his responsibility was established because of the default. The jury never knew that it was never established that he caused these harms. I fear that they went through this case thinking somebody found this guy really screwed up. How much are we going to give him? There ain't enough money in the world. So I think that, you know, the causation argument is going to look something like that.
And it seems tied to the rational relationship argument as well. Is that true?
A rational relationship is just another way of talking about it. Yeah. That's not like a legal concept that has legs and stands on its own in any meaningful way.
So oftentimes in a civil case like this, when people are claiming financial damages, they need to show evidence thereof. So like receipts, maybe they had some like mental anguish that Mr. Jones caused. And so then they might be showing receipts for long therapy sessions or other sorts of like, mental health attention. And you mentioned that in this proceeding, there was not a lot of that receipts, if any receipts. And there was just a lot of emotional arguments that were being made. So the parents, the Sandy Hook parents, were essentially saying that they were distraught and that they've suffered all sorts of mental anguish, etc. But there just wasn't a lot of data to back that up. And that is something that you generally expect in a proceeding like this. Can you elaborate more on the kind of the emotional nature of the arguments made by the plaintiffs against Mr. Jones?
You know, the most compelling argument involved a man named Robbie Parker, who is the only plaintiff whose name Alex ever used. He didn't even know who some of these people were until they sued him. He referred to them as the Sandy Hook parents. But in the Parker case, the day after his daughter was murdered by Adam Lanza, Parker appeared at a church where he thought he was going to give a statement to some local media. And when he got out of the church, there was the world's press and a huge bank of microphones. And before they went on the line, he gave a nervous giggle in response to something he said. And then he gave a very moving statement about his daughter. Alex and his people showed the world the video of him giggling and said, "What man laughs in the wake of his daughter's death? This is a crisis actor. This isn't true." And they never showed the rest of the video. So this video was shown to the jury any number of times as proof that Alex acted in callous disregard of Mr. Parker. Parker testified that it was devastating to him to be accused of having faked his own daughter's death and to be a crisis actor, and that as a result, he experienced hatred from people around the world, including a violent threat against him by an unknown man on the streets of Seattle. And that he had trouble sleeping and that it was angering and, you know, and so on and so forth. And for this, the jury gave him $120 million for harm to his reputation and the emotional distress that he suffered in the past and foreseeably will suffer in the future. That's a lot of money. And, you know, this without testimony of having gone to therapists, this without testimony that he lost wages, that he lost a job. Certainly, we live in divided times and deniers are problematic. I'll never forget the first time I ran into a truther. It was a 9/11 truther. And, you know, I was in New York the day before the bombing, arguing in a courthouse not far from the Twin Towers. And so I regarded myself as lucky. It was a near miss. A year or so later, I was talking to a good friend of mine who's a very prominent lawyer, an Indian lawyer, does a lot of work with the Shoshones. He started talking about how 9/11 was a hoax. And I'm like, what? What are you talking about? He said, look, there was no, that business about a plane running into the Pentagon, it didn't happen. And this was a lawyer I really respected and still do. And I thought, what in the world are you talking about? So next thing you know, we're online and he's showing me pictures and he's got the cursor and look at that. That's not this. And, you know, I'm listening to him and I'm thinking, this makes sense. You know, in terms of a lawyerly presentation and interpretation of the evidence, he's got some traction here. But yet it was crazy, the conclusion in my mind. So I listened to him. I humored him, actually, got off the phone. And then I've spent a lot of years thinking about that. And I thought, why in the world was he so unprepared to accept the narrative the rest of us accepted face value? And I think the answer is because of the nature of the pain that he lives in and experience and has experienced as a member of that reservation. The American Indian people obviously had a land taken from them, and you bury your heart and your relatives at Wounded Knee, right? And that's his personal history. So I think a lot of the truthers take a look at the world around them and say, well, I don't trust what I see. I don't trust what I'm told. And what's more, when I see others who are harmed, why is it that they get a privileged place in the national psyche, but my own harm, my own injury, my own struggles goes ignored? And I think it builds a stream of resentment that makes these communities of deniers possible. And I think it was on display in Sandy Hook. So the argument that the plaintiff's lawyers made, the best argument they made, they had a social media expert on, a guy named Clint Watts, who testified that in a given couple-year period, a couple of Mr. Jones's websites had 550 million impressions. And so they argued that each impression was worth something. Was it $1? Was it $2, $5, $10? And that the jury should assume that each of those impressions carried hostile information about people. And the jury should feel free to award $550 million per plaintiff, which would have been 8.2 trillion or billion, I think. The jury rejected that argument, but did pretty good by these folks. But that's as good as it got. And that was an argument by counsel. And so, we filed a motion for remitter, a motion to have the judge reduce the verdict, saying, this was a complete failure of the plaintiffs to address their burden of proof. Yes, they were harmed. And yes, on the law of the case, that harm was presumptively caused by Mr. Jones. But who relieved them, the plaintiffs, of the burden of coming up with a number? It's not enough to just throw a jump ball into the jury and say, we want a lot of money. You guys figure out how much. 550 million is a good place to start. That's converting jury service into little more than a trip to the casino and a judge into a one-armed bandit. And I think my client, hated or not, is entitled to better.
The Robbie Parker clip was quite a famous clip, and it's something that came across my purview just in my everyday meanderings on mainstream social media websites. So I'm curious, Norm, are you convinced that originated from Alex Jones, or is that something that could have just been floating around the internet that popped up on Mr. Jones's radar and thus was kind of covered on that platform?
If anybody else produced it, I'm unaware of it, and I think the evidence at trial was indisputably that Alex created it. But the question I had, and the judge wouldn't permit me to ask the question, and this was one particularly shocking part of trial. They with their social media guy, they showed that Alex's web traffic increased steadily from 12 to 13 to 14, doubling in 16. And they tried to suggest that all of this was because of Sandy Hook. So I've had a witness on the stand, and I said, well, what else happened in 2016 that was a newsworthy event? And the guy looked at me and said, how about who was elected president that year? Objection sustained. I couldn't answer. This case is not about politics, Mr. Pattis, I was told. But yet in their own exhibits, they had Alex Jones referring to Hillary Clinton as a, quote, sea hag. They had a picture of Barack Obama where Jones said, he's trying to take our guns. I said to a witness, who's that man in the picture? Is that Barack Obama? Objection sustained. I tried to offer evidence from their own exhibits about politics. They objected to their own exhibits on hearsay grounds. I'm like, the nuts are running the asylum. If you offer an exhibit, you're opening it to inquiry, but the judge protected them. So I don't know what happened there. Judge Bellis is no spring chicken. She's been at it for a while and is an experienced jurist. But the trial was a bitter disappointment in terms of fair process.
Can you speak about that specifically, that bitter disappointment?
I could, but I want to keep my law license. So, a particular, there was a sidebar. Sidebar is where lawyers and the judges talk, presumably out of the jury's presence. These were all recorded in the course of this case because the judge wanted a complete record. So no one would ever suggest that something untoward happened, that there were silent shenanigans. Well, at once and early in the trial, early in a trial, everything is contested. Everybody's fighting for every inch, and things can get a little tense. And so things got a little tense between the other lawyers and me. Not any more so than usual, but she didn't want it. She wanted everybody to behave, and she kept threatening contempt. And she'd bring us up to sidebar to admonish us. And at one point, after being admonished, she said, "Look, I've not been disrespectful to you. to the lawyers. And, I'd appreciate it if you'd extend the courtesy to one another and, yada, yada, yada. What can I do to make you treat one another better? She was very good that way. And I said, and I probably shouldn't have, I'm not going to debate the merits of how people treat whom. There was a jurist in this state who read something about proceedings in another state and decided to hold a show cause hearing, attacking a lawyer's license and having choice words about the lawyer that we reported in the international press. But I don't want to talk about that here. And that lawyer was me. In a Texas case related to Sandy Hook, tried by a colleague of mine, it turns out that information, confidential information, he obtained confidential information, turned it over to the other side. Much was made of it. And so this judge in the newspaper during our trial basically attacked my law license and other parallel proceedings, and those proceedings still pend. I don't want to talk about those. I've pled the Fifth Amendment on the stand in that case, and I don't want anything I say here to be construed as a waiver of that. But it struck me that in this case, Alex never had a chance, that from the get-go, the deck was stacked against him. He was held to a standard of perfection and then punished financially in a way I have never seen a plaintiff punished ever. His lawyers were attacked routinely, including me, all for appearing in court and having the temerity to demand fair procedures for their client. People don't like Alex, that's fine, but we don't tar and feather people in the United States, not in a courtroom anyhow.
The plaintiffs argue that Alex Jones was growing because of his coverage of Sandy Hook, but Alex Jones was growing the entire time since the mid-90s when he was on public access in Texas, as you stated, and then all the way through until Donald Trump comes onto his program in 2016. And that is probably a big inflection point for Alex Jones, and a much larger one than his coverage of Sandy Hook also. I think he probably gained a lot of followers as well during the 2008-2009 financial crisis and the Great Recession, as it were called. So I'm not sure if it's totally believable that a lot of Mr. Jones' success was because of his coverage of Sandy Hook.
And my view is once the other side opened the door as to his increase in traffic, they had to live with answers, and among the answers was the election. And then they had the audacity to offer an exhibit and have it read to the jury where people internally were boasting about Donald Trump. This was in 2018, saying to Alex, I'll never let you down. And so when I tried to inquire about that, objection, relevance, sustained. The trial couldn't be about politics, except it probably was, and the jury was kept from knowing that. And so, we never did find out how it is that 16 family members just happened to find themselves in a lawyer's office 6 years after the event to bring this action, and we probably never will find out.
In many ways, Alex Jones has mellowed out over the years. So I think that he was once a lot more libertarian-minded than he is today, and I think that just as a matter of personal maturation, he's kind of become aligned a little bit more with mainstream ideas versus the police. He used to be a lot harsher on the police, and he softened his stance there, which I think aligns more with popular opinion than his former opinion and approach.
I don't think that Jones is self-consciously political, meaning I don't think he woke up one day and say, I'm going to go this way or that. He's been talking about the growth of what he calls the deep state, what political scientists and social scientists might call the administrative state, something that's been with us since the Great Depression. And, you've got the Chevron decision and deference that we owe to administrative agencies. And then we had a recent EPA decision, or Clean Air Act decision, I think it was at the end of the last term, basically saying, look, under the separations of power doctrine, there are 3 branches of government, not 4. And we have this after 9/11, this growth, this explosion of expenditures and the number of intelligence agencies and agents in the country. We've got big data with Bill Gates survey and the surveillance state, and censorship through Facebook, Twitter, and these other things. And we've got the ability, like Shoshana Zuboff's book, to me, was an amazing exploration of the impact of big data on our world. The title of the book is The Age of Surveillance Capitalism. And her thesis was simple, and I think true. And that is that, social media lets you go onto their sites for free. And then it monitors what you like, what you look at, how long you look at it, and it aggregates that big data. And when it does so, it's looking for patterns, and it groups groups you with other people who have similar patterns, and then they make predictions about your behavior, how you're likely to be, what you're likely to want to see, what you're likely to want to buy. And I think that Jones has for years been worried about this, and he's been talking about it. And I think Trump tapped into a sense of populist rage as people feel that this country is one step beyond their reach. What makes the great dystopians is the following. 1984. Your television is watching you. You've got to do your exercises in the morning. You don't know if somebody's watching you when it's on the screen, but if you don't do them, well, it's for your own good. If you'll stay fit, you'll stay happy. If you'll just follow the program, you'll be secure. Aldous Huxley's Brave New World. Eat your soma. It'll make you glow, and you'll be happy. Fahrenheit 451, Ray Bradbury, don't read these dangerous books, just go along to get along. Margaret Atwood's Handmaid's Tale, a male dystopian universe where women are just meant as procreative devices. In each case, there is a dominant narrative controlled by an elite. And if you'll go along with the elite, you'll be fine. But every protagonist says, I don't want that. I want to decide for myself. And so I think that's what the Trump presidency represented. And I think that Trump and Jones converged at that point. And I think that led to the explosion of interest in Trump and Jones. And, the question nobody asks is Donald Trump's not my idea of a chief executive, frankly. And when he announced his candidacy, I laughed. But in the end, I voted for him because I felt like this guy's telling people off. I'm a deplorable myself. When Hillary said that, I said, yeah, I'm a member of that club. Thank you, Hillary, for giving me a name. Donald Trump spoke to the rage of people who feel disconnected from their society. What made Donald Trump possible? It wasn't that he lied. It was that there is this fundamental sense of dis-ease in our culture. Same thing that contributes to Jones's popularity. Same thing, I suspect, that contributes in a different way to Ye or Kanye West's popularity. And people aren't asking the critical questions. What is going on in our country such that we respond to this form of leadership? And the answer is we have a crisis of legitimacy. We don't share common norms. People are afraid, frustrated, and scared. And and that's what we have, is we have fear speech. You only hate what you fear. You don't hate because it's fun. And all the emphasis on hate speech is an emphasis on shutting up dissent for people who want to control the mainstream media. I fear those people. And I would rather stand with the people they're fighting or they're accusing, whether it be Donald Jones or Alex Jones, Donald Trump, Kanye West. I'd rather defend those people against the righteous than stand with the righteous any day, anytime, anywhere.
That's an epic statement. So I just want to be clear, I'm not saying that Mr. Jones sort of changed his demeanor to cash it in any way, shape, or form.
People ask me all the time, does he really believe what he says? Absolutely. I have spent hundreds of hours with that guy at his kitchen table, in his car, in meetings, on the air with him, in restaurants. And I've never seen him give the cynical wink that says, there's a sucker born every minute. He's responding to what he's seeing in the world, and people are listening to him because what he is saying resonates with them. And until people start asking what that is, we're going to get this whole discussion wrong.
You mentioned Clint Watts, the social media expert who appeared in the trial on behalf of the plaintiffs. He's featured regularly on mainstream media, or at least he's been featured on mainstream media. I wanted to note that the most erudite internet minds I know would take any sort of data about a website at face value unless it came directly from the back end of a website.
Well, and so that was a disputed issue at trial. The position of folks at InfoWars was that Google Analytics is a proprietary product. You log in with a password, and it tracks the sites that you make it aware of, and you can get information about who's using you and what their behavior as they use you, and afterward, and maybe beforehand. The Sandy Hook parents accused Jones of target marketing his content, of having people in one room saying, let's monitor what our traffic today, people in another room saying, let's talk about A, B, and C. And at the end of the day, they'd correlate A, B, and C. And the topic they talked that generated the most analytic traffic was topics they talked about. And that was their theory of the case. It didn't happen. And Jones and company didn't keep Google Analytics data. And so they kept asking for that data to be turned over. And we kept saying, but we don't have it. And we're not giving you our password. And we were never ordered to give the password. In the end, at the very end of the trial, somebody did run about 4,000, or just in the run up to trial, did generate about 4,000 pages of Google Analytics. And we turned them over, and they said, see, to the judge, we knew they had it all this time, and she issued another sanction, and so the case was just filled with moments like that. Watts was able, you're more savvy than I am about this tech stuff, but Watts had tracked ISIS and Al Qaeda and other groups for law enforcement and their use of social media and the internet. And he was able to use third-party sources to track some of this and come up with some estimates of numbers.
When it comes to analyzing all this internet traffic, I think we're going to really learn a lot about it in the coming decade, about how much of it's coming from bots. I think we've seen that play out with Twitter. Apparently a ton of the traffic or accounts on Twitter are owned by bots. We're being told constantly to look out for Russian bots or ISIS bots or those bots or these bots. I think over the coming years, we're going to learn that a significant amount of the internet traffic online is actually coming from like botnets, for instance. And I think a lot of people already accept this.
Let me give you the title, though, and you and your listeners, the title of a fascinating book by Watts. I read it in the run up to trial, and I can't remember the title. I want to get it right. It's his only work of nonfiction. That was a funny story. But it's Clint Watts. Doggone it! I'm on my Apple device here, which is probably
Messing with the Enemy.
Yeah, Messing with the Enemy. There it is. Surviving in a social media world of hackers, terrorists, Russians, and fake news. And so, he testified that he'd done a lot of work for big corporations about how they try to attract engagement and how clicks yield revenue. And then he's testified that those same techniques are often used by terrorists to motivate basically lone wolves to go out and do things. So I said to him, well, you're not saying Mr. Jones is a terrorist, are you? No. And is but what he was using the same techniques that I guess Coca-Cola was. But because what Coke was selling is caffeine that we all need at the end of the day, and Alex was selling misinformation, he got punished. But as I say, I'm hoping we can get that reversed on appeal.
These are just basic business practices that all small business, medium-sized, large business leaders have to do in order to survive in the market. They're techniques that have probably been around for a very, very long time. They were well documented, I think, at least particularly in the 20th century. There's a lot of text on this type of stuff. And so as far as I see it, Alex Jones is just doing the things that Alex Jones needs to do in order to stay in business.
They're trying to put him out of business. That's their goal. And so, we're on the front lines. And, with deplatforming, he was one of the first to get deplatformed. Now it's a common phenomena with respect to the use of litigation to silence him. The plaintiff's lawyer said in opening statement, we want you to stop Alex Jones. And so that wasn't a compensatory damages argument. That was a punitive damages argument. And, they're still trying to stop him. And I've got a message for him. It ain't going to happen.
I would tend to agree. It doesn't look like it's going to happen. So there's been some talk of a FBI agent that somehow is tied to this case. Could you maybe elaborate on that? I'm not really sure the details. I do know that he feels entitled to some claim, although his name never was uttered by Mr. Jones.
When the Sandy Hook shooting made its, when word of it passed through law enforcement, a bunch of FBI agents were on a SWAT team were in training on a field, and they gathered their gear and ran to the school. One of them was a man named William Oldenburg. Oldenburg went into the school, and what he saw was just awful. And you can imagine, children blasted to death. He left the school, and thereafter he learned that somebody was accusing him of being a crisis actor, and that he and another Sandy Hook family member, I can't remember the man's name, photos were held up on InfoWars comparing one to the other. And the suggestion was that they were the same person, and this proved that it was crisis actors. And this was deeply distressing to him, he said. So how distressing was it? Well, as a result of what he saw at Sandy Hook and of being misidentified, he went to the employee assistance program. Oh, how many times? Maybe a dozen. Oh, did you go? Well, sometimes we talked on the phone. How long? Oh, sometimes 10 minutes, half an hour. Didn't submit any bills for it. That's it. And then he testified, I can take this. I'm a big guy, I'm law enforcement. I understand it. But he did cry on the stand, whether he was crying about the misidentification or about what he saw in Sandy Hook is unclear. I might not have made that clear to the jury. But that was his testimony. You know what his verdict was? $90 million. $90 million for that? That to my mind is absolutely crazy, and it suggests that there was something wrong with that jury, or with the information that the jury got, or the impressions that they were given. Misidentify me and say, Pattis is a crisis actor. Look, there's this other guy who's in the media who's really well known. He's got a big nose and long hair, and he's profane, just like Pattis. It's Howard Stern. I'm not going to be happy about it. I don't want to be Howard Stern. I mean, maybe I do in some other life, but I don't want to look like Howard Stern. But is that worth $90 million, even if it made me cry? I mean, that's absurd. And I think in terms of promoting respect for the law, a verdict like this undermines respect for the law. You can hate Alex Jones until you run out of self-righteousness, but you're going to depend on the courts if you get in a jam. And if this is what it takes to get a $90 million verdict, move your money to another country.
You mentioned precedent at the beginning of this interview, so I wanted to dive in those a little bit. So if the appeal doesn't work, then what precedents are being set? What is your greatest fear about a case like this and what could result?
With respect to George Floyd, Candace Owens does a movie over there on the Daily Wire, The Greatest Lie Ever Sold. Kanye wears a White Lives Matter hat, and then he starts talking about Candace's film. He's on Drink Champs and says, George Floyd wasn't killed by the cops. Fentanyl killed George Floyd. And so this goes viral. So the family is now going to sue, not for defamation because Floyd is dead, but they're going to sue apparently on behalf of the daughter on the theory that this will cause her emotional distress. And people will hear this in the world at large, and they will harass her. And the result of that harassment will be that her peace of mind and enjoyment of life is diminished forever. So rumor has it the suit's going to be for $250 million. Would that have happened but for the Alex Jones case? I don't think so. I think what will happen if Kanye gets a default and he gets the same sort of justice that Alex got, and the jury is told that everything's his fault, well, that's one young woman could get that kind of money. But if the case is presented to a jury and causation is tested, it may not work that way. And what's more, in the Floyd case, I think the evidence at trial was there was enough fentanyl in his system to kill him. I think the evidence at trial was there was no evidence of trauma to the neck. Now, the jury rejected that argument. It's on appeal. I still think the Floyd case could potentially have been won at trial. And I think he should probably, not the Floyd case, what was his name? The Chauvin case. I think Chauvin should get a new trial.
You also mentioned that you were looking into Kanye West recently based on his recent statements and also the backlash to them. So what should Kanye be keeping an eye out for? This is your time for a message for Kanye.
I do a podcast of my own now called Law and Legitimacy. It's on Rumble. We live stream every morning at 8, and there's an archive of them somewhere in the video. I had a radio show for a while since I saw you last, but I got canceled after the Alex Jones show. So now I'm back to podcasting, and my producer and co-host is a guy named Mike Boyer, and Mike is a Ye fan. And so he's been talking about him for a while, and I'm like, the guy's married to Kim Kardashian. How serious could he be? Serious as a heart attack, it turns out. So this all erupts, and I think it's got something to do with Alex. And so I've been reading up and watching as much as I can about Ye. There is the Netflix special Genius, Jeenusays. There is the Lex Fridman interview, which I mentioned earlier, and I encourage everybody to watch. And so I think that Kanye has been summarily executed by the woke. He's been cut off from revenue streams without notice or an opportunity to be heard because his speech was prima facie offensive. I think he's got the economic wherewithal to fight back if he chooses. I also think he has the economic wherewithal and the social clout to build separate networks. And I gather he's thinking about buying Parler. And so I don't know where he goes from here. I hear people talk about him running for president in 2024. I mean, I laughed when Trump did it. Maybe I shouldn't laugh so hard when he does it, but I just somehow don't see him. I was laughing when I was watching him the other day, thinking, who would he appoint to the Supreme Court? It's Ice-T. I just don't know. So I don't know what happens next for him. But what I do cherish is his fiery spirit of independence. He's as he points it out, I'm not just I'm not just the richest black entertainer. I'm the richest black man ever. And he's worth, he says, some $11 billion. And he's a young guy from my perspective, maybe not from yours, but he's 46 years old with decades of creative energy ahead of him. So I'm hoping he takes his money, he marshals it with people close to him, and he says, who is my base? Who am I talking to? And why are they listening to me? And how can I continue to serve them? Because I think if he does, people will listen. I don't think he'll be silenced any more than Alex Jones will, any more than Donald Trump will. It's that kind of world.
And luckily, he'll have people like you to defend him. We've had the honor and privilege of sitting down today with Norm Pattis, one of America's top lawyers, right up there with Robert F. Kennedy Jr. How cool is this? We've got a Kennedy fighting big, massive corporations and a Texas cowboy who yells and screams into a mic too much and gets himself into trouble. Norm Pattis, right up there alongside him. Thank you so much.
Well, thanks. You made my day. Thank you for the kind words. Next time we talk, I'll see if I can get my dog a little more tired. I had her out romping in the woods for a couple hours today, but she's a border collie, and her famous response to every bit of exercise is more.
This is where our culture's at. They would rather your dog be happy while listening to you talk than...
Athena, say hi. Athena, say hi. You're a star now. Now, what she's saying is, I only have eyes for you, Dad. So I get it.
Well, I'll let you two enjoy the rest of your day. Thank you so much for joining us today.
Thank you so much.
Thank you.
Bye.